On the Delhi list. I Item number 2,
Same order.
item number 3,
Item 3.
So that is on.
Millet,
What is this? Let us see item 3.
Millet, item 3, Millet, I am appearing for the appellant.
Ah.
Millet,
It's a
may
60.
be taken up on Monday, Millet.
Why? We have to have some work to do today.
No, Millet, I have, Millet, but Mr. Amit Sharma is Millet, my junior in this matter. He is indisposed today.
Okay. So and so appears for the appellant. None appears for the respondent. Adjourn.
But I am appearing for the respondent in this matter. Right? Your Lordships will kindly have a look at your Lordship's order passed on the 25th of July.
So the registrar original side has submitted a report.
That's
Hmm. Actually, the first order passed on in 2014 was to file the requisite number
Paper.
of informal paper books, failing which the appeal will stand dismissed without reference to the bench.
Right.
It was not filed, it appears. Then an application was filed for modifying the order by extending the time for filing the paper book
Right.
and to recall the order passed by Chief Justice Arun Mishra and Justice Joymala Bakshi as they then were. Subsequently, that GA 2326 of 15 came up before Justice Soumitra Paul and Justice Mirdara Sheko, and they delisted that matter with liberty to mention upon notice.
Right.
Thereafter, the application has not come up. So we have to list GA 2326 of 15
Right, sir.
in what is the appeal number?
This is 27.
17 of 2005. And where is Mr. Uday Shankar Bhattacharya? He is appearing online.
But on the last day, he was appearing online. I believe he's not coming to court now.
So we can list that application. Anjan. Peruse the reports submitted by the registrar original side. It is seen from the said report that Sexa 17 of 2005 is yet to be restored, and the application for recalling the order dated 22/4/2014 passed by the Honorable Division Bench in GA number 2326 of 2017 was last listed on 12/8/2015. Thereafter, the Honorable Division Bench directed the matter to be delisted with liberty to mention upon notice. The report states that the said application has not been listed subsequently, and there is nothing to indicate that Sexa 17 of 2005 has been restored. Let DA 2326 of 2015 in Sexa 17 of 2005 be listed along with this appeal. Because last time you said it is restored, but the report, registrar's report says it is.
It is not registered. They should be first.
So we will list that application. Then
My lord. Grateful, my lord.
in case it is not available, can you prepare one photocopy on set? That's
One minute, a copy of that may be served on us.
you don't have a copy.
We don't have copies.
No, it is available. All right. Case paper, sir.
Sir, I am appearing as Mr. Banerjee, Bhaskar Prasad Banerjee.
But I'll ask him to serve me a copy in that.
Let a copy of the set. You have got a copy of
My lord, in this matter, Mr. Bhattacharya and Aishwarya is appearing. I shall intimate them, my lord.
let a copy of the said application be served on the learned advocate appearing for the respondent assessor.
Grateful, my lord.
Item number 5,
Lord, I'm for the respondent in this matter. I have item number 6, 7, and 8 are my appeals against the same order of the
Your appeal.
tribunal. My appeal, my lord.
Hmm.
That may be taken up, my lord.
But who
5 is I'm for the respondent because
no, who will appear for
Mr. Kallal Basu appears. My lord, in this matter, 5 adjournments have been taken, my lord. Since the matter was.
appear for the appellant, my lord. My lord, today, my senior's wife, she's admitted in the hospital for some checkup. She'll be discharged today. Hence, my senior finds himself unable to come to court. My learned senior friend has raised an objection about adjournment, my lord. Next date, my lord, fixes will appear.
medical
That may be
emergency?
fixed, my lord, any day.
So
my lord.
5, 6, and 7.
5 is their appeal.
5 is our appeal.
7,
5
8
and 6.
is mine.
5 and 6.
5, 6,
7 and 8. 5 to 8, my lord.
5 to
5 to 8.
Yes.
We have heard so and so, so and so. It is submitted that the learned senior advocate appearing for the assessee is unable to attend court today, and adjournment is sought for. List the matter on what date you want.
Monday, Tuesday, whenever.
My lord, Wednesday, my lord, Monday would
Pardon?
be a month. Wednesday, my lord,
Monday,
Monday.
Wednesday.
When is
We are ready, my lord. So, deeply obliged, my lord.
grateful, man.
20th August.
Item number 9.
No, I'm for the respondent.
Dichi.
9 who will appear for the department?
My lord, I'm appearing. My lord, 9.
What is this?
Well, this is against a stats order
Hmm.
where the duty cess was not paid in spite of sales assessment, my lord, under this heading of classification, my lord. That was done under show cause. Interest was not levied in the show cause. Thereafter, in the order, interest was levied. They have challenged it to the tribunal. Tribunal has confirmed the amount of cess that is amounting around 1,87,000 only, but still date they have not paid a single penny, my lord. They have come in appeal against that order of the learned tribunal, my lord. If I may place, my lord, learned tribunal's order, which is at page, my lord, 20 of
One second, let them take the file. This is Casta 1 of 2025.
teenage. Only fixed. This one. 5 to 8. Appellant. I'll explain. Yes. Just give me that. Now, page 20. And page 24, my lord.
We'll just go through the order.
My lord.
ठीक है
But show cause notice was issued under section 28.
My lord.
Then it should have been done within 6 months.
No. Then by substitution, my lord, in 2011, my lord, that has been amended to
Customs
1
Act.
year. It has been explained, my lord.
No, the period 1 year was substituted with effect from 14/5/2016. The instant case, the show cause notice pertains to the exports done in May 2014 and August 2014. What was the position prior to 2016?
My lord, I'll just surprise, my lord.
If we should have the old,
It has been clarified, my lord. It is clarified within this order. I'll just check, my lord.
the proper officer shall within, now it is 2 years. With
Yes.
effect from 14, before 14/5/2016,
Yeah.
it was 1 year.
Yes. It was 6 months, thereafter 1 year. My lord.
So during the period when this export took place, the period was only 6 months.
No, my lord, they have replied. The department has replied to it. I have gone through it, my lord. It has been clarified to them. Yes, I just read that point. That gives me a minute, I shall show, my lord. My lord, that has been reflected in Learned Tribunal's order, page 4, the page number of the stay application, page 23, my lord, paragraph 14. Paragraph 14, my lord. If I may place, my lord. In this case, it is an admitted fact that at the time of export of goods, the appellant was liable to pay cess, which appellant failed to pay. Therefore, a show cause under section 28 was issued within time to the appellant for the export made during the period 05/05/2014 and 14th August 2014 on 13 May 2016, as with effect from 2nd of April 2011 under section 28, show cause notice could have been issued within 1 year. Therefore, the contention of the appellant that show cause notice is barred by limitation is not sustainable. This has been reflected in the tribunal's
So
order.
from where from he gets that with effect from 24/2011, it is 1 year. This book says it is only with effect from 14/5/2016. What in your book, see the footnote?
No, my lord, my book says the footnote inserted 16 September by Customs Amendment and Validation Act with effect from 16 September 2011, my lord. I may clarify with this
You show that book.
section 28. Provision is 3, subsection 3.
नीचे footnote.
Note in such.
So from 8/4/2011, it is 1 year.
It is 1 year, my lord. On your lap.
Then the other point is section 17.
My lord, it has
Section-
been dealt, my lord. Just the next page, paragraph 18, my lord. In fact, I may place, my lord, internal page number 5, my lord, of learned tribunal's order. In fact, provision of section 17(4)
Correct. There has been no reassessment of the duty.
No, my lord, we did not object to it. Only that, my lord, there is an annexure, my lord. For the annexure, my lord, the assessment has been done by them. So, as per the assessment and under the classification, they were liable to pay the cess, which they did not, my lord. Now, after they have taken release of the goods, they waited for it to pass through the green channel, my lord. Then some time has passed and we identified this issue and we have issued show cause, my lord. But the only the case that maybe is here with respect to the interest that was not levied in the show cause. Only with that respect, my lord, the order has been passed along with the interest that they have challenged. That part of the order has been in their favor, my lord. Only that part. Apart from that, 17(4) is not applicable, my lord, in this case, and 129 is also not applicable. That the tribunal has noted, the adjudication order has noted. So we have not gone in appeal against that learned tribunal's order with respect to the interest.
Interest.
So we have accepted to that effect, my lord. Now they are still yet to pay the cess part, which as per their assessment, my lord, under the same classification. We have not challenged the classification, my lord. What? Not so. It's so good.
But they refer to a decision of Honorable Justice Indira Banerjee. You come to page 30. They,
It is before 2011, I recollect. That's 2009, my lord. Before
2007.
no, order passed 2009, my lord.
No, writ petition of the year 2007.
Yes.
The shipping bills of the year 2004.
And the order has been passed before 2011, before the amendment, my lord. So the show cause time that they have referred is rightly passed. That judgment has been rightly passed. And Milord, that is reflected.
Pardon?
Milord, that is reflected in the page number 32 of this order, Milord, passed by Justice, Honorable Justice Indira Banerjee, Milord. That is reflected, Milord. By that, then also it was there. Just the last para, Milord. If I may place, Milord, provided that the proper officer may determine the amount of short payment of duty or interest, if any, which in his opinion has not been paid by such person, and then the proper officer shall proceed to recover such amount in the manner specified in this section, and the period of 1 year or 6 months, as the case may be, referred to in subsection 1 shall be counted from the date of receipt of such information of it. So it was in the mid of this substitution. So it is reflected. Then that 6 months period was there, my lord. And then the next page, my lord, if I may place, my lord, the last, just before the last paragraph, my lord, the show cause notice of page 33, my lord, I'm referring. The show cause notice issued to the petitioner in the instance case was in itself barred by limitation, and to recover can be made on the basis thereof. In addition, the impugned order has been passed after expiry of 6 months from the date of issuance or even service of. So, my lord, then it was passed under the consideration that the limitation period is 6 months from the date, my lord, relevant date, my lord, of for passing its show cause, my lord, issuing a show cause. But in this case, it has been extended to 1 year. So it is not covered by this judgment, my lord.
See, if you did not object to the self-assessment, it is deemed that the shipping bills were duly assessed. Once the assessment has been done, the duty has been paid, and let export order was given, and the goods have been exported. How do you reopen the matter? That is why he is referring to section 129D. Without doing that, you come to 129D.
Yes, well, may I please, my lord? 129D, my lord. The section 129D, powers of board or commissioner of customs to pass certain orders. The Committee of Chief Commissioners of Customs may, of its own motion, call for and examine the records of any proceeding in which a Commissioner of Customs, as an adjudicating authority, has passed any decision or order under this Act for the purpose of satisfying itself as to the legality or propriety of any decision or order, and may by order direct such commissioner or any other commissioner to apply to the appellate tribunal for the determination of such points arising out of decision or order as may be specified by the boards in its order, provided where the Committee of Commissioners of Customs differs in its opinion as to the legality or propriety of the decision or the order of the Commissioner of Customs, it shall state the point or points on which it differs and make reference to the board, which, after considering the facts of the decision or order passed by the Commissioner of Customs, if it is of the opinion that the decision or order passed by the Commissioner of Customs is not legal or proper, may by order direct such commissioner or any other commissioner to apply to the appellate tribunal for the determination of such points arising out of the decision or order as may be specified in its order. The Commissioner of Customs may, of its own motion, call for and examine the records of any proceedings in which an adjudicating authority subordinate to him has passed any decision or order under this Act for the purpose of satisfying himself as to the legality or propriety of any decision or order and may by order direct such authority or any officer of customs subordinate to him to apply to the Commissioner of Appeals for the determination of such points arising out of decision or order as may be specified by the Commissioner of Customs in his order. Every order under subsection 1 or subsection 2, as the case may be, shall be made within a period of 3 months from the date of communication of the decision or order of the adjudicating authority, provided that the board may, of sufficient cause being shown, extend the said period of another 30 days, where in pursuance of an order under subsection 1 or subsection 2, the adjudicating authority or any officer of customs authorized in this behalf by the Commissioner of Customs makes an application to the appellate tribunal or the Commissioner of Appeals within a period of 1 month from the date of communication of this order under subsection 1 or subsection 2 to the adjudicating authority, such application shall be heard by the appellate tribunal or the Commissioner of Appeals, as the case may be, as if such application were an appeal made against the decision or order of the adjudicating authority, and the provisions of this act regarding appeals, including the provisions of subsection 4 of section 129A, shall, so far as may be, apply to such application. 5 has been repealed, my lord. After repealment, it has come. The provisions of this section shall not apply to any decision or order in which the determination of any question having a relation to the rate of duty or to the value of goods for the purpose of assessment of any duty in issue or is in one points in issue, my lord. Therefore, my lord, this order has been passed by Deputy Commissioner of Customs, my lord. And there is no question or any ambiguity with respect to the cess element that has not been paid by them, my lord. And they have not challenged to the cess, my lord. My lord, there is an annexure at page 27 giving details of the cess against the FOB value, my lord, along with the show cause, my lord.
Who appeared for the assessee?
My lord, it has been, the AOR is Pratyush Chatterjee, my lord, of this matter, my lord. May I place the order part, my lord? My lord has raised a query, my lord. May not kindly consider page 51 is about section 28 has been discussed how it comes under section 28 thereafter, my lord. With respect to 129, it has also been explained in page 51, 5.6, my lord. May I place, my lord? 51 of the stay application, my lord. Paragraph 5.6. Exporter Mrs. Ratan Maika Exports Private Limited has alleged that the procedure of section 129D2 has not been followed. Therefore, the issuance of the show cause notice is arbitrary and is bad in law. They stated that if the assessment is final and the consignment has been released by the proper officer after being fully satisfied in all respects, Department can initiate action for recovery of dues through initiation of provisions of section 129D2 of the Customs Act 1962. In the instant case, said shipping bills were self-assessed and RMS facilitated, for which no assessment, RMS facilitated. So it has been input done like that. An examination was prescribed and therefore no assessment and examination was done. So this has been RMS facilitated, must be some technical facilitation, my lord. Therefore, Section 129D2 does not apply and question of review does not arise. Section 28 of the Customs Act 1962 states that the duty is not levied or short levied or erroneously refunded or any interest payable has not been paid, part paid or erroneously refunded for any reason other than the reasons of collusion or any willful misstatement or suppression of facts may be recovered from the concerned person within 1 year from the relevant date. Thus, Section 28 of the Customs Act squarely covers the violation on the part of the assessee. Therefore, thereafter, may I kindly place the discussion findings part. Section 17 has been discussed in page 50, section 50 and 17.
Section 17 deals with assessment of duty. Please take
17.
section 17.
Yes. Well, may I place 17(1). Assessment, an importer entering any imported goods under section 46 or an exporter entering any goods under section 50 shall save as otherwise provided in section 85 self-assess the duty if any leviable on such goods.
So,
2. Yes.
no. So, an importer entering into the imported goods so and so, or otherwise provided and so on so, self-assess the duty if any leviable on such. Here he has self-assessed. Then the proper officer has to
Yes.
verify.
May verify, my lord,
May verify
that
entry so and so, and for the purpose and the self-assessment of goods. You skip 46 and 50. The proper officer may verify the self-assessment of goods referred to in subsection 1, and for this purpose examine or test any imported goods or export goods or such part thereof as may be necessary. Then proviso you can skip. Then for the subsection 3, the proper officer may require the importer exporter to produce any document, etc., etc. So here once he makes a self-assessment and he determines the rate of duty in terms of section 16, the shipping bill is deemed to have been assessed. So therefore, whether this finding rendered by the authority saying that merely because it is self-assessed, there is no assessment and examination. No, it's not correct.
it has been self-assessed.
Self-assessment is the see, once you accept, you don't question the self-assessment, it is deemed that it has been assessed.
But we accept the self-assessment, but that
So
cess
then,
part he did not pay.
129D will apply.
My lord, he did not pay the cess part, my lord. We are not questioning his assessment. There is some duty part, there is a cess part.
So,
He did not pay the cess part.
Cess also partakes the character of a duty.
My lord,
Ah.
my lord.
So
But he did not pay, my lord.
He didn't pay. He didn't pay. But you were satisfied with whatever assessment he has made. Let export order was given. The goods were exported. After close to nearly a year, you did not take any action. Then you issued a notice under 28. What he says is 129D you will have to follow.
No.
So as to.
My lord, I recollect, my lord, there is a judgment, my lord, Escorts Limited, my lord, wherein the same issue has been discussed. Today, I'm not equipped with that judgment, where it is said that the assessment, they have self-assessed the duty, they did not pay or short pay the duty, and they take release of the goods. Then also, the duty, because it is self-assessment, we may or may not question the duty, but we are not denying.
Is an assessment.
Is an assessment, and no final order of assessment is required to be passed further in furtherance if we accept the self.
So how
I'll
do you
bring that
reopen
judgment.
self-assessment?
But
You have to resort to 129D.
No,
Not
my lord.
under 20.
My lord, if I fail,
All
my
right.
lord,
None appears for the appellant.
I
You
bring
have
that
heard
judgment.
Manasi Mukherjee Learned advocate, standing counsel for the respondent. List next Wednesday or so.
Deeply obliged, deeply obliged. But what is my intent?
My lord, I am for the appellant, my lord.
Hmm.
Now, this matter is very simple question, my lord. They deposited the duties, my lord, on protest. And for the period, my lord, 2014 to 15. And my lord, they waited till the judgment pronounced by the Honorable Supreme Court on 26 March 2015. And my lord, they made the claim on 6 February 2018. My first question is that, my lord, the claim itself is hopelessly barred by the law of limitation. Article 137 residuary article, if your lordship sees, any application for claim, my lord, that has to be made within 3 years from the right to apply accrues. That apart, my lord, section 27(1) capital B small b of the Customs Act kindly looked into, my lord. Kindly look into, my lord. Section 27, subsection 1, capital B. As your lordship got it, my lord.
Hmm.
My lord, may I read, my lord? Save as otherwise provided in this section, the period of limitation of 1 year shall be computed in the following manner, namely A is not applicable. Then B, where the duty becomes refundable as a consequence of any judgment, decree, order, or direction of the appellate authority, appellate tribunal, or any court, the limitation of 1 year shall be computed from the date of such judgment, degree, order, or direction. Therefore, the protest which was made by them as per section 27 subsection 1 proviso, that has automatically, my lord, evaporated. There will be no effect. My lord, they made their application on 6 February 2018 after lapse of 2.5 years, even after the order passed by the Honorable Supreme Court in SRF matter, my lord. And my lord, that apart, if I come back on the date he made the application, my lord, it was for the period of 2014-15, my lord, 3 years long back it was expired. Therefore, protest cannot be continued for an indefinite period. A protest, my lord, cannot be continued for an indefinite period because the Limitation Act does not, my lord, save the litigant that he can continue his limitation as he wants to choose. Therefore, my lord, 2 points, my lord, if your lord kindly sees, my lord, the section 27 1b small b is very clear. The judgment pronounced on the Supreme Court, that was, my lord, 26 March 2015, he could have made within 1 year. He didn't do it. Therefore, his claim hopelessly barred. He is not entitled to get any refund. That is the first point. And second point is that, well, even if I say that yes, he has a claim, then claim has to be made within, my lord, 1 year. If your lordship kindly consider the article 137 of the Limitation Act kindly says, my lord, may I place it, my lord, for time being, my lord. Article 137 of the Limitation Act says, any other application for which no period of limitation is provided elsewhere in this division, 3 years when the right to apply accrues. Therefore, my lord, he is not entitled to any claim. That is all my case, my lord, though it was held by the tribunal, also appellate authority, that he is entitled to. But, my lord, this aspect has not been considered. The statute specifically provided this bar. It cannot be superseded by any judgment, my lord, unless it is declared as ultra vires. Now, my lord, my question framed is here, my lord. If your lord takes up the questions are there, my lord, in my memorandum appeal, para 22. and my stay application, my lord, para 24.
But here, the duty, it is not disputed by the department that the duty was paid under protest.
My lord,
If
my
the,
lord, my lord, that is there, my lord. Duty was paid under protest. But how long, I put this question to myself, my lord, how long the protest will continue?
protest will
his right
continue, protest will continue till you pass an order of reassessment or pass an order saying that his protest is unjustified. You have to pass a speaking order affirming your assessment. See, you make, section 17, he makes a self-assessment.
my lord,
The proper officer is entitled to examine whether the self-assessment is proper or not.
my
If
lord.
he finds it is not proper, for that purpose, he can order for examination of the goods, etc., etc. So once he does that, and he comes to the conclusion that the self-assessment is not proper, then you come to subsection 2. No, subsection 3. He has to require the exporter or importer to produce documents whereby the duty leviable on the imported goods or export goods can be ascertained, and thereupon such person produce document and furnish information. Subsection 4 says, where it is found on verification, examination, testing, or otherwise that the self-assessment is not done correctly, proper officer may, with prejudice to any action which may be taken under this act, reassess the duty leviable of the goods. So,
Now, my lord,
this reassessment is to be done after issuing show cause notice.
my lord,
Then only it becomes final. Until then, the protest will continue eternally.
Hello.
So when you have, so therefore the tribunal observes the decision in ITC will not apply.
Very well. Decision ITC not applicable.
There are
But
other
my
high
lord,
courts also you are carrying.
my lord, may I then, my lord also can consider the statutory provision which provided here, my lord, why he had made the claim, there was no reassessment that is there. No,
My lord, page 16. Page 16 of the compilation. Page 16.
My lord, then what
Not
about the My lord, what about the judgment of Supreme Court? Supreme Court, my lord, once judgment passed in SRF, my lord, matter, then, my lord, section 27, subsection 1, capital B, small b says that he will have to make an application within 1 year. My lord, then in that event, my lord, if that sustained, then this section will become nugatory, my lord.
Para 4 and then 6 onwards. Para 4 and then para 6 onwards.
So Mapatlal Industries is very clear.
Yes, my lords.
Well, I do not know whether Mofattal Industry deal with this section, subsection 1, capital B, my lord, in section subsection B. And because he made the application, why? Because the Supreme Court says that he's entitled to get back the duty. That's why he's make the application. In that event, he upon, my lord, relying upon the judgment of the Supreme Court, my lord, then, my lord, the section 27, capital 1B and small b comes into play. I think this question has not been dealt with anywhere. My lord, suppose, my lord, I lent money somebody. Can you appreciate? I lent money somebody and he didn't refund it to me, my lord, or didn't take any steps. Now, my lord, I waited years together. Then I come with a money suit asking, please bag me the money. Well, then what about the Limitation Act?
Lords, in a
Protest
seemingly
cannot be
similar matter.
continued for an indefinite period. My protest cannot be continued for an indefinite period. My lord, department didn't do anything, my lord. Department is very bad. Now, my lord, question is that for an indefinite period, he waited. And
My lords,
2018, my lord, waited for 2018. Even the Supreme Court judgment passed in 2015, he made the application after 2.5 years. What prevented him to make the application within 1 year? There is no explanation as to that.
Lords,
Then, well, what about the provision made in the Customs Act 27(1) capital B small b?
Lords, 2-3 more points I would like to say, if permitted chance, my lords. My lords, ITC point that they are raising, it was never raised in the show cause notice. Show cause notice merely was on the point unjust enrichment.
No, we are not raising ITC
time
point
bar.
now. We are not raising ITC point now. We are raising this section 27, subsection 1B, small b.
My lords, and apart from
That should be explained here. ITC has gone.
No,
Even at that-
sir, Mr. Bhattacharjee, please appreciate the legal position. Once a duty is paid under protest, it means, what does it mean? He has not paid it voluntarily. So, what you have to do, you have to hold that the protest is unjustified, and you have to pass a speaking order of reassessment in terms of section 17. Right through, it has been accepted that duty in respect of 174 shipping bills has been paid under protest, and the word used is the protest has not been vacated. How do you vacate a protest? By passing a reassessment order in terms of subsection 4 of section 17. Very, very simple point.
My lord, then, my lord, may I answer, my lord? May
Pardon?
I answer, my lord?
Yes.
Suppose, my lord, may I answer to your lordship, my lord? Suppose, my lord, the department accepted that it is protest is correct. Since there is no order, therefore protest is correct. Now, my lord, how long he'll waited for getting the money to be refunded?
Sir, maybe, sir, he has waited for more than 1 year after, or 2.5 years after the judgment of the Supreme Court, whereby the benefit of a notification stood extended in favor of the exporter. What Mafatlal says, which it says the second proviso to section 11B, as amended in 1991, expressly provides that the limitation of 6 months shall not apply where any duty has been paid under protest. Now, where a person proposes to contest his liability by way of appeal, revision in the higher court, he would naturally pay the duty. Whenever he does under protest, it is difficult to imagine that the manufacturer would pay the duty without protest, even when he contests the levy of duty, its rate, classification, or the other. If one reads the second proviso to subsection 11B, along with definition of relevant date, there is no room for any apprehension of the kind expressed by the learned counsel. No, the rule no doubt requires the assessee to mention the grounds of protest, grounds for payment of duty under protest, but it does not empower the proper officer to whom the letter of protest is given to sit in judgment over the grounds. The assessee need not particularize the grounds of protest. It is open to him to say, according to him, the duty is not exigible according to law. All that the proper officer is empowered to do is to acknowledge the letter of protest delivered to him, and that acknowledgement shall be proof that the duty has been paid under protest. Reading of the rule shows the procedure prescribed therein is evolved only to the to keep a record of payment of duty under protest. It is meant to obviate any dispute whether payment is made under protest or not. Any person paying duty under protest has to follow the procedure prescribed by the rule, and once he does so, it shall be taken that the duty has been paid under protest. The limitation of 6 months will then have no application. We may clarify at this stage when the duty is paid under the orders of court, or whether by an order granting stay, suspension, injunction, otherwise, pending an appeal, reference, or writ petition, it will certainly be a payment under protest. In such a case, it will be not necessary to lodge a protest under Rule 233 capital B. That is the legal position.
That is, your lordship, I
Though
understood.
Mofatlal arises under the Central Excise Act, it is in parameteria with this provision. When you have accepted, that is why the tribunal followed. And there are other decisions. Right on the point is that Allahabad High Court.
This very judgment.
Page 16.
16, 17, yes.
16 and 17, which followed Mofatlal. And there are other tribunal. There are no High Court decisions other than.
No, my lords. My lords, High Court decisions are on other point. My lords have recently passed one order in the case of Power Grid, wherein they took a similar view applying ITC, that assessments once finalized cannot be reopened. There, my lords held that even though the bill of entry was finally assessed, however, because there was a price escalation contract established through the documents, therefore assessments have to be deemed to be provisionally assessed. Therefore, ITC would not have any application. My lords, same thing the tribunal has held in this matter.
Please come. This appeal filed by the department.
My lord, one more point, my lord. My lord, in Mofatlal or Allahabad, my lord, both matter is
Corrected
dealing with
against the order dated 2/5/2024, passed by the Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Calcutta, within bracket Tribunal, in Customs Appeal number 75200 of 2023. The revenue has raised the following substantial questions of law for consideration. Page number 14.
15.
14. Question A. B not required. C. All right. B and C. We have heard so and so. The admitted facts are there. No, sorry. The revenue is agreed by the order passed by the learned tribunal, dismissing the appeal, their appeal, filed challenging the order in appeal, dated 16/6/2022, passed by the Commissioner within bracket Appeals, Kolkata. By the said order, the appellate authority held that duty paid under protest tantamounts to challenge to the assessment, and further challenging / modification of the assessment for the purpose of refund. In such case, the application of the decision of the Honorable Supreme Court in where is the citation?
My lord, citation is
ITC?
2019 VIL. My lords. ITC.
सर इतना तो नहीं वो जो सुप्रीम कोर्ट का ऑर्डर जैसा
ITC ना
नहीं आईटीसी नहीं सर SRF वाला बोल रहे
my lords, what ITC citation or SRF?
Supreme Court order.
Supreme Court
Yes, sir.
in ITC Limited was says
ITC का मांगा है.
2019 VIM 32 SC-CU did not apply. Further, the appellate authority held that the department has not disputed that duty has been paid under protest by the respondent for all 174 bills of entry, and no infirmity can be attributed to the impugned refund order for not fulfilling the requirements of challenge/modification of the bills of entry in terms of the decision of the Honorable Supreme Court in ITC Limited. Accordingly, the appellate authority affirmed the order in original dated 24/5/2021, by which the original authority sanctioned refund amounting to rupees 7,98,08,012 paid against 174 bills of entry under section 27 of the Customs Act 1962. The contention raised by the department before the learned tribunal as well as before us is that the ratio of the decision of the Honorable Supreme Court in the case of ITC is clear that unless the assessment order is not modified as per law, the refund claim under section 27 doesn't arise. That is, the refund proceedings cannot be used as a substitute for appeal proceedings, and the effect of under protest is only in the context that the time limit under section 27 would not apply. Further, it was contended that the very protest made by the respondent came to an end after the decision in SRF. Have you given SRF to this?
My lords, citation.
After the decision of the Honorable Supreme Court in SRF Limited versus Commission of Customs Chennai 2015 318 ELT 607 within bracket SC. And the protest made by the respondent would not survive beyond the date of the judgment of the Honorable Supreme Court dated 26/3/2015. The learned tribunal considered the said contention raised by the revenue, but rejected the same after taking note of the decision of the coordinate bench of the learned tribunal Identical issue came up for consideration in the case of Kisan Cooperative Sugar Factory Limited versus Commission of Central Excise 2018 8 GSTL 365 within bracket Allahabad. The court took note of the decision in the case of Mafatlal Industries Limited versus Union of India, 1997 89 ELT 247 within bracket SC. No, before that. Let that sentence remain before that. In the said case, the assessee filed a refund application after 4 years in the year 2009, and the same was rejected, invoking the provisions of Section 11 capital B of the Central Excise Act 1944. In the said case, though the tribunal found that the assessee therein had made the deposit of the disputed demand of duty amount under protest, rejected the refund application on the ground of limitation, because according to the tribunal, the assessee therein made the refund application belatedly after expiry of 1 year from the date of judgment of the court. The court took into consideration the decision, the same sentence, of the Honorable Supreme Court in Mafatlal Industries versus Union of India, 1997 89 ELT 247 within bracket SC, and held that in view of the specific finding recorded that the duty amount has been deposited under protest, limitation of 1 year to make the claim of refund under Section 11 capital B would not apply at all to such a case, and therefore the amount is liable to be refunded to the assessee appellant therein, along with interest, excluding the period for which the appellant therein had not applied, that is up to 2009, from the date it became liable to be refunded. Direction was issued to the effect that the principal amount is to be refunded, but no interest be given from the date of the writ petition. No interest be given from the date writ petition was allowed to the date when the appellant therein made the application for refund, that is 2009, and the interest beyond that time may be given. In there are other decisions of the tribunal on the very issue, holding that the assessee paying duty under protest and intimating to the Assistant Commissioner by letter that since it required consignment urgently for its product, it would be clearing goods on payment of duty under protest, and such protest lodged by the assessee would remain till disputed issue was settled finally by higher appellate forums. And in the absence of any order showing indicating vacating of protest on an adverse order having been passed against the assessee, duty having been paid under protest would not be hit by limitation. prescribed under section 27 of the Customs Act. Furthermore, in Sinkai Synthetics and Chemicals Limited, sorry, it is in page 34 in para 6. Synthetics Limited versus CCE Aurangabad, two 143 ELT 17 within bracket SC. It was held that refund of duty paid under protest will not be hit by the bar of unjust enrichment. Unjust enrichment. A 3-member bench of the tribunal in the case of Collector of Central Excise versus Prestige Engineering India Limited, India Private Limited, 1989 41 ELT 530 within bracket tribunal, page 30, held that once a protest has been lodged, it becomes the duty of the assistant collector to dispose of the protest by an appealable order so that the assessee could go in appeal against those orders. Full stop. Unless the assistant collector disposes of the protest in the aforesaid manner, as enjoined under Rule 233 capital B, the protest cannot be deemed to have subsided. A 3-member bench of the tribunal in the case of Commission of Customs, Tuticorin versus Sakti Sugars Limited, 2020 372 ELT 577 within bracket TRI, full stop, hyphen Chennai, bracket close.
It's 2-member bench.
38. It was held that
But this is 2-member bench, my lords. 2-member bench. Shakti Sugar.
then you say the coordinate bench of the
2 members.
Malad Shakti Sugar, my lord, we have preferred the appeal before the department preferred the appeal before the Madras High Court, which is pending for final judgment.
It was held that the marking of protest itself gives information to the department that there is requirement for reassessment. Full stop. Assessment under section 17 of the Customs Act, 1962 cannot be said to be finalized when the respondent therein has marked the protest while paying duty. Full stop. It was further held that the mark of protest is an information to the department that the assessee is not making payment of cess/duty voluntarily, and then department has to initiate proceedings to vacate the protest and pass speaking order of reassessment. Similar view was taken by the coordinate bench of the tribunal in HDFC Bank Limited versus Principal Commission of GST and Central Excise 2027 TMI 362-Sestraction, page 40 of the compilations. Ballapur Industries, why you have kept?
My lords, because ITC issue was not raised in the show cause notice.
Okay. So that is para 21 of the judgment.
Yes, my lords.
Yet another ground which was canvassed by the respondent assessee is that in the show cause notice which was issued, the department did not rely upon the decision of the Honorable Supreme Court in ITC Limited with a proposal to deny refund.
My lords, small point. ITC judgment came afterwards. They could not have relied it. But again, the principle they did not call out in the notice that assessments are already final, therefore no refund.
Then we will not touch upon that. You shut up. And what is this notification?
Notification
30/2004.
It's 7.
My lord, this is the notification under which we were claiming exemption.
Okay.
Relevant notification.
Now, from what date have you been given? Because in that decision which says,
My lords, refund, very pertinent question by my lords. We got assessment order in our favor. We got appellate order in our favor. Still, they did not give us refund till 2023.
oh,
So refund इन्होंने इतना लेट दिया है हमको.
the learned senior standing counsel appearing for the appellant would contend that even assuming the refund is to be sanctioned, interest is not payable. We had noted that in Kisan Cooperative Sugar Factory Limited, the court denied interest for the period of delay. That is from the date on which the writ petition filed by the assessee therein was allowed till filing of the
refund
application for refund. But here you will not get interest for the period from the date of SRF judgment till the date of application.
My lords, even the law says that after 3 months of the application filed, refund should be granted. We are claiming interest for that period only.
Oh, you have not claimed ante.
Lord, we are not claimed from the 2015, my lords.
In the instant case, the respondent has not claimed interest from the date, from the initial date, but they have claimed interest only after expiry of a period of 90 days from the date on which the application for refund was granted. Therefore, such objection raised by the revenue would not arise in the instant case. For all the above reasons, we find that the learned tribunal was fully justified in dismissing the revenue's appeal. For the above reasons, the appeal dismissed and the substantial questions of law are answered against the revenue. The appellant revenue is directed to effect refund in favor of the respondent together with interest as ordered within a period of 3 weeks from the date of receipt of the server copy.
petition फाइल किया बोलोगे सबको इंटरेस्ट के ऊपर कुछ फाइल नहीं किया था.
Obliged, my lords. Lord, same is item number 11.
But the thing is that, my lord, the date of order in original should be different and the bill of entry also should be different.
174.
No, my lord. Here, my lord,
174, they were
137 bill of entry.
Give that file, sir. We'll order, short order will pass. Item 11. This appeal filed by the revenue is directed against the order dated 2/5/2024 passed by the Customs Excise Service Tax Appellate Tribunal, East Zonal Bench, Kolkata, within bracket Tribunal, in Customs Appeal number 75201 of 2023. The revenue has raised the following substantial questions of law for consideration. Page number
Page number 15, my lord.
15.
A similar question of law, my lord. Question of
15
law.
A, B, C. Others not. We have heard so and so. The impugned order passed by the learned tribunal is a common order in two appeals filed by the department challenging the orders passed by the commissioner within bracket appeals, Calcutta. In respect of the appeal filed by the department before the learned tribunal, in Customs Appeal number 75200 of 2023, the revenue challenged the same by filing an appeal before this court in Custa 2 of 2025. And by judgment dated 2nd August 2025, the appeal was dismissed. The operative portion of the judgment reads as follows. After you type that, then we can get extra. The above decision will squarely apply to the case on hand, except for the difference in the number of shipping bills, which is how many shipping bills?
My lord, page 33. If your lordship kindly come to page 33.
My lord, bills of entry.
Yes, bills of entry, my lord.
Sorry, not shipping bills. Bills of entry is 137.
137 and thereafter, my lord.
137 were rejected. Allowed were 1999.
Yes, yes. And second is that three shipping bill. Second is 10 lakhs.
Totally how many, sir?
My lord, 96.
96.
99.
96. And the amount of refund ordered is different, except for the same. In all other respects, the decision in Custa 2 of 2025 will squarely apply to the case on hand. Thus, following the above decision, this appeal is dismissed and the substantial questions of law are answered against the revenue. The appellant department is directed to effect refund together with the interest as ordered within a period of 3 weeks from the date of receipt of the server copies.
Obliged, my lord.
Refund
Next.
Interest.
My lord, do you have refund has already been only portion of interest to be made, my lord. As I am being informed.
Refund instead of the interest only interest.
My lord, in case of 3 weeks, some time may be granted if your lordship.
6 weeks.
Grateful, my lord. Grateful.
Next.
Obliged, my lord.
My lord, we are grateful, my lord.
12.
My lord, on the last occasion, my lord has instructed me to obtain instruction whether we
You didn't have breakfast, I think.
today.
Your voice is not coming.
My lord, this is my
Even with this microphone, we are not. Last occasion, what did we do?
my lord asked me to sort instruction whether we will accept the monetary limit notification. My lord, the instruction is we'll proceed with the appeal, my lord. But just seeking an accommodation for today, my lord.
No. You can proceed with the appeal. You will have to meet that point, no? No, what? We didn't pass any order. No. Advocate respond and submit. So,
Yes,
so.
yes.
On what ground do you like to proceed? You get
On
written
merit, my
instruction.
lord. My lord, on merit.
You are
my lord.
directed to get written instruction.
Yes, I have.
Better get written instruction.
I
You
have.
meet his preliminary objection. We have heard so and so. The learned advocate appearing for the appellant department seeks time to get written instructions in terms of the earlier order dated 21st March 2025. List them and give a date after 2 weeks.
Deeply obliged, my lord.
I'm for the respondent, madam. I'm led by Dr. Chakraborty. He's in the
He's online.
Lordship, so far as the issue is concerned, is squarely covered by your Lordship's judgment as well as the other judgment. That the money which is paid for the sugar sales, he can take a input credit.
Credit, yes.
I
Lordship,
brought the judgment also.
no, no, please, I'm admitting.
Please give.
So
the
Lordship, this all judgments which are passed by your Lordship is prior to 2009. Means the period is 2009. Till January 2009, the law of the land was, there was a sugar cess. You have to pay, it's your duty. And moment it has been paid, we said, no, you have to pay the duty in excess of that. Lordship's all, no, both are same, he can take input credit. Now, if someone makes a payment of a cess or makes any payment anywhere, which is not mandated by law, then can he take the input of that? That's the question in my this appeal. And the limit as required is also there. Lordship, what happened in January 2009, the cess has come to an end. So no more he is under obligation to pay cess. So now he is no more to obligation to pay cess. He paid cess somewhere. And Comsman can say, though I paid it wrongly, I will take input credit. So Lordship, what?
No, we can do one thing. We can ask him to reverse the credit, but you refund the cess.
Yes, Lordship, that has to be. Credit has to be.
Refund means with interest. Compensatory.
And for the delayed payment, then I am entitled to interest.
Decision you show.
Lordship, kindly see.
Sir, no amount of tax can be collected
Two decisions,
without
my lord.
authority of law. Okay.
Another.
But then he has, suppose, Lordship, kindly see, for a matter where it is not required under the law, he pays.
You can't benefit from his wrong.
No, I am not. But then, Lordship, he also cannot compel me to take something which is not coming to my fund. That fund has ceased to exist. If your Lordship kindly takes up one circular, it are a copy though. 7/1/2009. If your Lordship kindly takes up this circular. Lordship, by this circular, this has come to an end.
Exempts the levy of cess on sugar.
So, Lordship, that's it. Now, Lordship, if we every time feel that he has paid only to a government department, so I have to give a input to him.
Mr. Banerjee, you have not raised this point before the tribunal. Department can't become wiser when they come.
No, Lordship, what I'm saying, this is a pure question of law, Lordship. If your Lordship kindly allow me, otherwise, Lordship, this revenue, if he has deposited something in an act which we might not also get back, because that the fund ceased to exist, the account ceased to exist. So, Lordship, if something ceased to exist, then he does it. And Lordship,
so if it ceases to exist, you cannot retain that money. You cannot retain that.
That's what Lordship.
Refund. See,
from the concerned department, he will get it. No, Lordship, kindly see. Lordship can. It's not like a single house, Lordship. That my budget for my car EMI and house EMI is same. End of the day, I have to pay. The Lordship is not like that. Lordship, kindly appreciate. The question of law here is, Lordship can remand it back, or Lordship we can rethink on the issue. But here, once it is not there, if he pays, and then he tries to take back the import, then Lordship, why do we stand? Then the Lordship, this will make an incident that if it is done, then we can give it to the Prime Minister's relief fund and I can take test steps. Because I changed my mind. I will not donate anything to the Prime Minister Relief Fund. So give me a exemption there. Lordship, then that thing stands there. So far as Lordship's judgment earlier, well, he has paid, so Lordship has equated it is expenditures.
No, the stand taken by the adjudicating authority was that the sugar cess, no credit is available. That was the ground. And therefore, the tribunal tested the correctness and it followed
that's right.
The earlier decision.
Lordship, then in the tribunal,
Sir, the earlier decision is in the assessee's own case.
Karnataka High Court.
This is what I'm saying. But all those are prior to 2009. But this period is after 2009. Lordship, kindly see.
And what happened to the appeal in Supreme Court against Karnataka?
Lordship, I have inquired. Since it was below the threshold limit, no, it was referred to the Lok Adalat, where one of the sitting Supreme Court judge and Mr. Vipin Nair, a practicing lawyer at Supreme Court from Kerala, they constituted it, and then they formulated that this is not a right case to proceed with because this is not in the threshold. This is the only case I have in the whole India which is in the threshold limit and in 2009. Otherwise, Lordship, any fund will not give him a relief. I understand clearly what Lordships has stated and other court has stated. So, Lordship, now it is not required by him to do something in law, he will do and take care of it. Lordship, we cannot consolidate the entire fund of my country into one. That I have deposited somewhere, I will take care of that. Lordship, this is extremely difficult. Lordship, then Lordship, kindly admit the appeal. And Lordship, I will make further what are the possibilities, then we can remand back and go back to the tribunal and we can raise this issue. But Lordship,
even in your substantial questions of law, you have not raised this point.
Only no, I have. Yes.
Please show page 7.
No. No, Lordship, circular has been stated there. I think so. Yes, ground 5, if your Lordship kindly takes. I have taken specifically that ground, that circular also. If you want. In the stay, Lordship, I have specifically said. And if your Lordship kindly takes my
then what happens to that cess which he has remitted?
Lordship, then we will find out a way. But then, Lordship, if the law we makes this, then Lordship, not only we have a cess, we have so many.
Right. In the assessee's own case, now the Karnataka High Court judgment has become final.
So far as prior to 2000.
So when was that export done?
Those are all prior to 2009. And this is only after January 2009. Lordship, the period involved here is this is a clearly period after that period. Lordship, period here is October 2009 to June 2030.
To June
2030. And Lordship, in all other matter, those are all prior period.
Yes, we will have on this point. We'll ask Dr. Chakraborty, what is your contention, sir? Please unmute.
Page 224.
Sir, please unmute. No, yeah, are you able to hear us? I think some problem with their audio.
Record.
She is making a call. Sir, she is making a call. So, Lordship, what I'm saying here is this matter, probably, Lordship, this is over threshold, and Lordship, this is beyond the period. The question deviates from that. Earlier, Lordship,
the problem is we are going to test the correctness of the order of the tribunal on a ground which was never canvassed before that.
Lordship, it's a ground or not ground in this case.
No. That needs to be adjudicated. No.
So, Lordship can remand it back there because I said I am not allowing you to take the credit. But why? I am saying I am not allowing you to take the credit.
Yes, sir. Are you able to hear us?
ভাস্করকে একটু বলতে বলো, আমি 5 মিনিট আসি। Lordship can,
All right, we'll have it on Tuesday then,
except Tuesday, Monday and Tuesday I'm out of station.
Wednesday.
Wednesday.
You please inform this point and you are,
I've handed over a copy.
Yes.
you have heard so and so, so and so.
Yeah, just shop আমার
List on Wednesday.
Lordship can record a small.
What do you say?
Lordship kindly record that circular I have handed over to.
We'll return it.
Yes, yes, I have given to him. I'm deeply.
Next.
14:15, I am seeking time today. My senior Mr. Narasimhan will argue this matter virtually on Monday or Tuesday, whenever convenient, next date. Not today, my lords.
Anytime.
My lord, kindly, my lord, takes up after 1 week, my lord.
After?
My lord, after 1 week, my lord.
After 1 week, they want. At the request on either side, give a date, sir. The item 14 and 15.
14 and 15.
Your Lordship, Mr. Obrotosh Mojumdar is appearing in this matter. He is not there today. Kindly make his not today.
And this matter I am led by Vipul Kundolia, so I am also going for the accommodation.
right.
Item number 16 and 17, Your Lordship.
16 and 17 at the request of learned advocates on either side. Adjourn, you give a date.
May please, your lordship.
Deeply obliged.
Lordship, can you remember the case where
Who
the
will appear for the department? Come.
Mr. Bhanjam?
Hmm.
The issue is here, my lord.
You amended the invoice as a result of
Yes,
the excess
Yes,
payment.
excess payment made. Now the question is that appellate authority, due to delay payment of the delay filing of the appeal, they have dismissed my appeal. So they have considered my facts of the case also. And against that, we have come before the tribunal. Tribunal also considered the facts, but came into the conclusion since it is a delay filing. So now the question is, my lord.
No, appeal was dismissed only on the ground of delay.
Only on the ground of the delay.
Where
Your
is
lordship asked me to find out one of the judgment where the High Court has directed the tribunal to consider not only the delay point in the merit also. I have found one judgment of the Madras High Court where it is considered in that way. But before that, I have another 2 points, my lord. That point is that it is a 35G appeal before your lordship. And if any substantial question of law is involved, your lordship may consider and formulate the question and consider the point. Now, my lord, one of the case here, when they have issued the show cause notice, they have alleged about the imposition of the penalty, but they have not, and at the same time, they have taken the extended period of limitations. My question is whether this show cause at all maintainable or not, because there is some judgment of our high courts also, though it is in respect of the 260A appeal, where High Court says jurisdictional point also the substantial question of law. And so in 260 appeal, it can be considered which is not that point not taken earlier. For the first time, it has been taken. So my respectful submission also, if your lordship can consider the show cause notice, there's only the sweeping statement that there is a suppression of facts. But what is the suppression? From the facts, I can show that there is no question of suppression. Even on the merit, in respect of the law also, it supports my case because before issuance of the show cause notice, I have made the entire payment again. So there is no question of penalty. And even in the proviso of section 11 AC also says that if I made the payment before issuance of the show cause, the penalty cannot be levied. So in that event, my lord, kindly allow me first to show the particular judgment of our division bench where says how the jurisdictional point is a substantial question of law. He could not understand most probably.
I called his junior also.
তুমি এই ওর ল্যান্ডলাইনে একবার ফোন করে বলো স্টাফ যদি কেউ থাকে because this is a Saturday, sometimes all the staffs in the chamber are late, that is why they are not picking up the call. আচ্ছা আমার কাছে আছে এটা জাস্ট
ঠিক আছে
এটা দেখো
বলে দিয়েছো তো
First, kindly take 2
copy as
paragraph. First of all, the paragraph. Oh, huh. Sorry.
ঠিক আছে
এখান থেকে
ঠিক আছে, বলো 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 ঠিক আছে
First, kindly take paragraph 3. The first question relates to the interest for the delay deposit of the tax deducted at source. Section 201(1)(a) capital A is involved. It is the said that the assessing officer for the assessment year accepting only one wrongly passed the orders in regard by the notification number so and so dated 10th of April 1989. The jurisdiction in that regard had gone over to the ITO TDS with effect from 8th of May 1989. The aggregate amount of interest exceeds 3 crores on merit. The SSC was not successful. The point was also taken for the first time only before the tribunal. We first brought the point of jurisdiction does not involve a substantial question of law, but only a petty or a hole-picking one. Next, section 260A1 reads as follows. An appeal lie to the High Court for every order passed by the appeal by the tribunal if the High Court is satisfied the case involves a substantial question of law. Now, we are of the opinion that the phrase substantial question of law means any question of law which affects the substance of the case. The High Court is satisfied that the question is one of law, and if decide in favor of the appellant will substantially affect the taxability and or some other matter in the case, then the High Court is compelled to entertain the appeal. Cannot entertain the appeal only on the points of law which are somehow brought in by it sufficiently serious. Now the question formulated that paragraph 10. The third issue relates to the natural justice. For the assessment year 1985-86 only, the correct officer had exercised the jurisdiction, but he had not heard the SSC. The SSC was, however, fully heard in appeal. We were still minded to entertain the appeal because of the various authorities quoted in so and so case. And if the first authority does not hear the SSC loses its chance to being able to pursue the first authority to hold in its favor. The order of observations without prejudice and following questions shall be heard in appeal. They have formulated the questions, my lord. And the third one, where the proper and the common of the 4 assessment year 1983, 84, 84, 85, 86, 87, 1987, 88, the whether on a proper interpretation of the provision of the Act, notification number so and so, the order passed by the Deputy Commissioner Special Range 1 Calcutta were without jurisdiction and thus nullities and consequently were all the subsequent proceedings in respect thereof also show. So my respectful submission here, my lord, I can show from the show cause notice itself that they had not specifically stated what is my cause for imposing for the availing the extended period of limitation, my lord. So if I can succeed on that point, my lord, that show cause will go and your lordship can decide the issue in 35G appeal here also. That is my first case, my lord. So my lord, kindly take the show cause notice first. What is the show cause here?
Only thing they say is assessee has willfully suppressed the above fact.
Only this.
Availment of irregular credit to escape from the knowledge of the department.
Yes, but it is not the case at all because I paid the tax twice here, my lord. And before issuance of the notice, show cause notice, once it is detected, I paid the duty. And not only that, I reverse the Senvat credit, what we availed. And from the return, I can show that always my Senvat amount is higher than the amount which I claimed here. So practically I am never claimed or availed this. So there is no question of the suppression, and as well as there is no attempt to evade the tax also. There is no deliberateness. So I have brought two judgments of the Supreme Court in this regard, which is a suppression as well as the when the extended period of limitation cannot be availed when there is no expressly it is stated in the show cause notice. My lord, kindly take the judgment of Supreme Court, my lord. তখন পাচ্ছিলাম না no. Lordship, kindly take paragraph 14. Acts of fraud or suppression, it is well settled, must be specifically pleaded.
Paragraph?
Paragraph 14, 14. Acts of fraud or suppression, it well settled, must be specifically pleaded. The allegation in regard to the suppression of facts must be clear and explicit, so as to enable the noticee to reply thereto effectively. It was not the case of the revenue that the activities of the appellant were not known to it. Next paragraph 19, my lord, after considering the other judgments. Furthermore, the extension of period of limitation entails both civil and criminal consequences, therefore, must be specifically stated in the show cause notice. And in absence whereof, the court would be entitled to raise an inference that the case was not one where the extended period of limitation could be invoked. Another aspect of the matter cannot be lost sight of. The appellant also known to the so-and-so railway raised the definite plea of the bona fide. Such plea had not been rejected. As a matter of fact, considering the imposition of penalty under section 11A of the Act, the Commission has refused to impose any penalty upon the appellant on the premises on the guilty of the act of malafide, with therefore keeping in the view the fact, the circumstance of the case, or of the considered view that impugned judgment cannot be sustained, it is set aside. Accordingly, we hold that revenue was not justified in invoking the extended period of limitation in the instant case.
See, in your reply to the show cause notice, come to page 106.
Yes, ma'am.
para 4.2.1.
Yes, my lord.
You are referred to an order passed by the Deputy Commissioner. Is a very valid ground. On, if you read, in this context, we like to bring to your attention to the order dated 37/2015 passed by the Deputy Commissioner. At the time of passing such an order, the department was well aware of the fact that so-and-so had wrongly availed the Senvat credit of excise duty, thereafter had made reversal, but no objection was raised.
So it is known to the department, my lord.
And where is that order? 37/15.
That order in original, my lord.
Deputy Commissioner's order.
Deputy Commissioner's order not with me, my lord, as of now.
All right. In the order in original.
Order in original, they have not discussed anything. They have not. Anything they have not discussed. And I have given the typed copy, my lord, over there. And there are discussion and findings at 138 onwards, page.
138.
138.
There is no finding regarding
Extended period of review. Complete. That's the
Then
one.
it is gone. See, twice they have paid. How it came? And
the thing is that my lord, their availment, that one invoice, my lord, initially they have raised.
then you should not have accepted the reversal. See, if they had availed credit because of the invoice value got changed, then they realized no, this should be done. So they reversed it. How you can retain?
Lord, they have suo to reverse this amount. Therefore, my lord, in the show cause notice, my lord, it was proposed that the quantum of
for a single clearance, how you can demand excise duty twice?
Lord, we have not. They have paid it. One invoice, my lord, they have raised. Goods was not clear. Subsequently, another invoice, goods was clear. Now they have paid twice, my lord. Now, when they have paid, they cannot show motto. Take the credit. There's a procedure. If you have paid it,
This was aware. Department was aware in 2015, but you waited, and in 2016 you issued the show cause notice. So therefore, there should be a clear allegation of suppression. 10/11/2016 show cause was issued. And what do they say for extended period?
my lord, show cause notice page 99, my lord.
99, you come to that allegation. Third unnumbered paragraph, 4 lines from the bottom. Hence, it is evident has willfully suppressed the above fact of availment of irregular credit, escaped the knowledge of the department. Where?
If your lordship kindly see, my lord, page number 99, it is not legible.
Sir, he reversed it on 12/5/2015.
99.
On 37/2015, the Deputy Commissioner has passed an order. He was aware of that. And where is the question of invoking extended period?
দেখি কোথায় আছে? হ্যাঁ, ওইটাই দেখছি।
টাইপ কপি
টাইপ কপিটা দেখি তাতে।
না এটা এরকম।
এইটা।
Mr. Banerjee, here, extended period could not have been invoked because they reversed it on 12/5/2015, 12/7/2015. Oh, sorry, 12/5/2015. Deputy Commissioner passed an order on 30/7/2015. At that time, the department was aware. But they invoked the extended period, issued the show cause notice in 10/11/2016. And there is no allegation of willful suppression with the intent to evade payment of duty. Where is the question of imposing penalty?
But over here, well, subject to correction, it is only related to the condonation of delay.
That is why we are on a 35G appeal.
Yes.
there is a substantial question of law involved, nothing prevents the court from examining that issue.
Malan, only the question of law will be only relatable, Malan, subject to correction, is only relatable whether the delay can be condoned by your lordship under the statutory jurisdiction. Because this question of law is in transmission.
On merits, we can't touch. Why
No,
can't we
Malan.
touch?
Because the tribunal or the appellate authority has not decided.
Central Excise Act.
Central Excise Act.
Because the tribunal or the appellate authority has not decided on merits, but simply on the ground of
We will
limitation.
decide.
Well, your lordship is not exercising writ jurisdiction.
No,
That is the
That is
limitation.
why I've given this judgment. I have other judgment also.
It is a statutory appeal, therefore whatever the statutory remedies he has been.
Here's a question of limitation or not the issue. What is the judgment? Same jurisdiction point থাকবে তাহলে entertain করতে পারে, but in this case there is no question of limitation was the issue. This is a separate aspect. এখানে একটা question of law তে যেটা যেমন whether on the proper application of it, but this was not the issue here. It on the point of merit.
Say, an appeal shall lie to the High Court from every order passed in an appeal by the appellate tribunal on order so and so, so and so.
If the High Court is satisfied that the case involves a
Substantial
substantial question of
This is
law.
my case.
Substantial, where do you read in?
Malan,
Substantial question of law should be relatable to the order passed.
to the order passed. Malan, your lordship will be exercising jurisdiction in relation because it is not a first
Jurisdiction
appeal.
point also
It is the law which is.
This involves a substantial question
Yes,
of
the
law.
law involves, if I am not in the right tune, but the law involves relating to the facts which have been decided by the learned tribunal. Whether the learned tribunal is correct in interpreting that it does not have jurisdiction in exercising in deciding the issue that it does not have the power to condone the delay, or the assessee is not
That is
entitled to
why
the delay.
Mr. Basu's placed reliance on a division bench judgment of this court, which says that if the High Court is satisfied that the question is one of law, and if decided in favor of the prospective appellant, will substantially affect the tax liability or some other matter of substance in the case, then the High Court is compelled to entertain the appeal.
That is my case.
Any other decision, Yoga?
Yes, I have brought the judgment of Santosh Kumar Hajari, one of the famous decision. My senior used to apply this
Malan, if
judgment.
your lordship will kindly see the judgment in paragraph number 3, your lordship has decided with regard to the merits. It is not on the ground of delay. Paragraph number 3, the first question relates to the interest.
Correct. In
Yes.
that case, it was decided on merits.
On merits, but
So how do we interpret the words case involves a substantial?
yes,
question?
Malan, the case, Malan, my submission will be the case, the order is a finality of a
Judgment
decision
একটা আমার মনে
of the learned tribunal.
তুমি দিলে
Now, your
Tribunal
lordship,
didn't decide on merits.
yes,
দাগ দেওয়া রয়েছে তো।
Can it prevent us
Hmm.
in a 35G appeal to examine that? If it involves a substantial question of law, having direct relationship to the taxability or the imposition
well,
of
taxability or any issue has to be decided by the learned tribunal, either for or against. Over here on the ground of
But the-
limitation or non-exercise or exercise. Whether it is exercise of jurisdiction resulting in a positive or negative finding, your lordship has jurisdiction to entertain the same and take the notice. But over here, it refused to exercise jurisdiction on the ground of a technical plea that I am on the ground of limitation. I will not see the appeal or decide the appeal on merits.
But the problem is,
But over here, he has challenged that order before your lordship in a statutory appeal.
and he has raised grounds on merits.
Yes. Now over here, the grounds of merits can only be assumed or taken notice by your lordship.
Why
if the-
can't you argue?
Malan, though it is
It
not.
doesn't say is satisfied that the case involves substantial
Well,
question law relatable to the decision of
Well,
the
it has to be decided in terms of the every order passed in appeal. That every order, that means the merits of the order which is passed in appeal has to be a satisfaction of a substantial question of law. Every order, your lordship is examining the merits of the order of the learned tribunal.
The adjudicating authority order is not challenged under the federal lordship.
Because they have not challenged the adjudication order. That is my submission, my lord. My lord, because since it is a statutory appeal, and your lordship will kindly see the statute, lie to the High Court, an appeal shall lie from every order passed in appeal. That
Yes.
means the tribunal has to decide the finality or the decision-making process of the order of the learned tribunal on merits or demerits is before your lordship, whereupon your lordship assumes jurisdiction if your lordship find that in the said order or the impugned order.
If there is an order
Yes,
passed by the tribunal which is impugned in this appeal. So an appeal shall lie to this court from every order of the
Yes,
tribunal. There is an order. When it can entertain, if the High Court is satisfied that the case involves a substantial question of law. Now, every order you are trying to interpret every order to mean that the issue decided by the tribunal should involve a substantial question of law.
No, my lord. The issue which has been decided has attained a finality in a decision-making process. Now that decision-making process is before your lordship in a
How
statutory.
many days delay?
56 days. And I have brought one of the judgment of the recent not recent 2015 Supreme Court judgment. It is rendered by headed by Justice Nariman. It is held that because they are saying about the limitations. In the Singh Enterprise case, there is a one line that the Central Excise Statute specifically excludes the Section 5 of the Limitation Act. That line is there. But this judgment also says, suppose Section 14, Section 5 of the Limitation Act specifically is excluded by the particular statute, but principle will lie. I brought this decision also on that one.
দেখি দাদা কি দিচ্ছে। দাদা কি
দেবে না
দিচ্ছে?
No.
দাদা দেবে। তোমার দেবে না আজকে। তোমার মার্ক করা এটা কিন্তু।
ঠিক আছে।
Paragraph 30, 31, 32, my lord. Though it is the case of application of Section 14, it is the appeal preferred under Section 128 of the Customs Act, my lord. And before that, they have filed the appeal before the wrong forum. That is, they are trying to take the advantage of Section 14. And two arguments made by the department. First of all, the Limitation Act will apply in the case of only the court, not before the quasi-judicial authority, which Supreme Court not accepted. Second thing, another argument was advanced by the department that no, that principle cannot be applied in that way. But Supreme Court says no, while it is specifically excluded. But principle will apply here. That's Section 30 onwards. May I read, my lord, section, paragraph 30
We
onwards.
will continue. We will continue on Monday.
Top of the list, my lord.
Oh, yes.
Otherwise, it is a monthly list and it will go down.
Monthly list.
My lord, on Tuesday. My lord,
Tuesday.
original side here, these matters are taken up on Wednesday.
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 But it will be in a place that matter can be concluded.
You have heard so. You go through this.
Yes, my lord, we shall. And assist your lordship.
For continuation arguments, list on Wednesday.
আমি দেখে নিচ্ছি।
Judgment bar for it. You will order.
18 নম্বর item।
Sir, when we will take up your cricket association?
But we got, but we
today all of them. In fact, 10 o'clock I came. Then about 10:35, 10:40, I asked them to check up only. They said only 2 advocates are there. Then all right. Then now.
Let's, I think Monday is the monthly list, so Tuesday, if it commences to my lord, it can, but complete. It can be complete.
Mr. Kundalia will not probably be there till Wednesday, my lord.
Hey,
It
no,
will be taken up on Thursday. Because he has some,
It is, I'll be making submissions.
What
for-
is it? Amadev?
It will take time.
Mr. Kundalia, his junior is there, Mr. Sharma. Sharma is there, but he can take notes and then my lords can have it from. the-
Dharma is not well, is what they said. Let it come on Thursday itself.
Thursday, I have, or Friday, maybe.
Friday.
Omelette, may I suggest, let it be on Tuesday, if if Mr. Kondale is not here, my lord, we'll do it on Friday. then.
Friday, my lord.
All right, Friday. Right. Item 19 to 26.
20 to 20.
20.
19 some other matter. 19 who's appearing?
This is the rescue of
And as they've given instructions, this appeal has become infructuous, my lords. As in the last occasion, my lords has recorded an order.
And who will appear for the
As my
department?
learned senior friend Samarjit Roy Chaudhary
Chaudhary.
was appearing, my lords.
Let it remain in the list.
My lords. Deeply appreciated.
Then what about appellate side? We'll come back. Appellate side will come back.
Appellate side, daily list, serial number 1.
My lord, I am appearing for the petitioner. Mr. Mojumdar is leading the argument. He is not in court today. Kindly. Not today.
What to say? Not today. All right.
Serial number 2.
My lord, 2, 3, and 4, these are all connected. They all arise out of the same adjudication order. Now, at the outset, I have to say that initially the appeal was supposed to be filed along with the stay petition. Now, that has not been filed. The reason being that there are 3 volumes of annexures, and my learned friend had a bit of a crisis in his chamber. So the files have been reconstructed. I'm praying for leave to file the stay petition in the next few days, if possible.
But if it is actually in the original side,
yes, my lord.
If these there are voluminous, I think there is a rule which says
150.
150.
Yes, ma'am.
If you can restrict that. In fact, we are trying to adopt that for the appellate side as well.
We are doing that. We are employing it, and we have we've separated the files so far. But
what is the issue involved?
Right.
We have not been served, my lord. So a copy may directly be given to me, a hard copy, and
Without papers, Mansi will argue.
My learned friend had appeared before the Honorable Single Judge. So she is aware of the case, but I'll serve it anyway. So what happened in this case, my lord, is that this was a case originally about undeclared manufacture and removal of goods from the premises without excise duty. That was the issue for adjudication. Now, there were 4 issues with which the assessee came before this Honorable Court. 3 of them were procedural, out of which 1 was purely jurisdictional, and 1 was on merits. I'll come to the merits first. So, there's about...
so, writ petition was disposed of, relegating
yes, due to the alternative remedy being available, without any of those 4 issues being addressed in detail. Now, the main issue in this case was that the total demand made against all these parties is about 13 crores. The issue being that there's about 13 crores of goods which were manufactured and removed without any disclosure in the returns. The assessee traced out the consignments which were listed in the show cause, identified the actual manufacturers of the goods, went to the manufacturers, obtained certificates with the tabulated invoices, submitted to the department for consideration. Department acknowledged that evidence. This is about 50% of the total demand, around 6 crores worth. And having acknowledged that submission, in the discussion and findings, there's no attempt to deal with that evidence. So almost half of that dispute demand has not been addressed in the discussion and findings. This was one of the main reasons why the assessee was aggrieved. Now I'll come to the second issue. The invoice details and everything was obtained from a source. That was one of the transporters that the department had interrogated. Now, when this evidence was supplied by the assessee, this went to the root of the allegation. So the assessee called for the cross-examination. That cross-examination has been denied. So that became a procedural grievance.
But does the officer deal with that issue and say why?
Deals with the cross-examination, saying that there is adequate corroborative evidence to not allow the cross-examination. But the corroborative evidence is, this finding is challenged by the assessee in as much as the assessee has maintained that we have already supplied the evidence which counteracts that, and the corroboration that is being referred to actually doesn't corroborate. And that is apparent on the face of record. That is what the assessee had argued. The third issue specific to the writ was the notice of hearing. The order has been passed by the audit commissioner. That's the respondent number 2 in this case. Usually the audit commissioner does not pass the order, but the audit commissioner has passed the order in this case. Now,
but is he the proper officer?
He's not supposed to be the proper officer, but in the notice of hearing which he has issued, there's a reference to a certain circular and Rule 3 of the service tax rules, under which he had purportedly been given jurisdiction to do this adjudication.
But this is central excise.
Exactly, and this was the ground in the writ petition, that how can Rule 3 of the service tax rules be applied for giving jurisdiction in a central excise matter to the audit commissioner.
So the first 2 issues may have some factual bearing.
Right.
But the third issue which you are raising doesn't have any.
It's a pure jurisdictional argument. And the fourth issue was the entire hearing was ex parte. Given that about 50% of the demand was confirmed without the discussion which the assessee had stated, the assessee had contended that at the very least the hearing should be given. Now that there is a complication with the hearing. First, the case was taken up by the Executive Commissioner of Bolpur, who's the respondent number 3. He's the one who started the case. The hearing was concluded before him, but then he didn't pass the order. The matter was given to reassigned to the Audit Commissioner. Audit Commissioner gave one adjournment. Now, the learned chartered accountant who was dealing with this matter, his wife was suffering from cancer. He wasn't able to come, and the same problem has occurred to us. 3 volumes for each petition. Because the show cause notice was itself so voluminous. So the assessee they'd also given us a substantial reply with all the clarifications of the manufacturers. They weren't able to get that reply from the chartered accountant. So they went to the commissioner's office physically and informed him that they are not able to retrieve the reply, to give them a copy so that they can do the hearing, because they've already done the hearing. So the commissioner said, please give us the request in writing. They gave the request in writing. What they got in return was another notice of hearing. So the assessee repeated their request, no response. Assessee in the meanwhile procured the document from the chartered accountant within a couple of weeks, informed them, we've got the document, please give us the hearing. No response. Another 2 weeks went by, another letter by the assessee, we've got the reply, give us a hearing. They got an order, this adjudication order. So these were the 4 issues with which the assessee approached this.
But on the third issue, the man who hears should decide. That's the principle.
The man who hears has to decide. So he is given only one adjournment.
But if he hears he is unable to decide, then the next officer should have a de novo proceeding.
That's right. So what he has done is he's referred to the adjournments which were granted by the previous commissioner as a basis for denying adjournments on
if
this.
it is a case of violation of principles of natural justice, why can't it go back to the authority?
Why did they serve me?
You show the adjudication order you're carrying with you.
Adjudication order.
Just not having any memo or anything.
And it's a huge order. So
Yeah, it will contain a lot of
yes.
annexes. Only on that issue.
Well, I'll come back, my lord. Let them serve by Monday. They will serve.
Or we can request the single bench to decide those 2 issues alone. Whether there has been a violation of principles of natural justice, and instead of the matter hanging here, if it goes back, you get an opportunity. Yeah, we will say that 4 issues have been raised. Basically 4 issues.
Yes, ma'am.
Or primarily 4 issues.
4 issues.
Out of which we find 2 of the issues with regard to availability of evidence, etc. Whether the evidence produced by the assessee was dealt with or not, may require a factual adjudication. That is normally not entertained in a writ petition. On the second issue, whether a cross-examination is permissible, has to be mandatorily granted or not, also will revolve on facts.
Right.
Keeping these 2 issues aside, if the learned writ court can be requested to decide on whether the second respondent had jurisdiction to decide the matter and whether there has been violation of principles of natural. You can file a short affidavit in opposition only for those 2 grounds. If he succeeds on that, well and good. If he fails, he will take it on appeal here, or he'll go before the tribunal.
The main issue remains the 50% actually, because what has happened in the discussion and findings, there's just not even a line with regard to that. So this is, even though on natural justice that the assessee has agitated matters, but it comes down to that. Because it is interfering
if the court
with
is satisfied that you did not have adequate opportunity, matter has to go back.
Right.
We'll
But if I may serve it on the other side, let this honorable court keep it, because if I may serve it on the other side, then we can have a detailed discussion. Your lordship
It's an
can.
appellate side matter, so
Yes, ma'am.
matter can be taken up on Tuesday or.
Like, we are ready with.
As well as-
We are almost ready with the filing. Actually, he's done all the work.
Within a week, you will be able to file.
By Monday, I think we'll serve it on the other side.
But then she will require some time.
Of course, my lord. Of course, my lord.
A week thereafter, my lord, I'll come.
That is the 2, 3, and 4, is it?
Yes, sir.
2, 3, 4. And issues are all identical.
We have heard Mr. Chaudhary, learned advocate, is also, Manasi is also. It is submitted by the learned advocate for the appellant that due to inadvertence, stay application couldn't be filed, and they are in the process of preparing the same, as the documents are voluminous, and request reasonable time may be granted to the appellant to file the stay petition. Leave granted to the appellant to file the stay petition along with annexures Let advance copy be served on the learned advocate for the respondent department. List the matter. So today we are on 2nd. On 12th August.
Very good.
But a week thereafter, Monday is a monthly stage. So just next Monday, maybe. If
No,
my lord please.
12th is a Tuesday.
Well, this is Tuesday.
What date you want? You see the calendar and tell.
On Monday.
10 days, my lord. By after
12th?
from date, 10 days.
Very good.
Deeply.
Deeply.
Serial number 5.
Common order.
Deeply.
All the
Please,
three.
My lords, I appear on the behalf of the petitioner, my lords. The learned senior advocate Riju Ghoshal is leading me, my lords. He is not available in court today. My lords, may I kindly request for a hearing on Monday, my lords?
When do you want it?
Monday, my lords. Monday, the senior is available, my lords. It's a
Monday?
very short issue, my lords.
Mondays will be monthly list. We'll have it on Tuesday.
Very well, my lords.
At the request of the learned advocate appearing for the appellant, Tuesday.
Grateful, so grateful.
Serial number 6.
It is my case, my lord. The issue involved is only 15 hours delay, but the waybill expired.
200% penalty. 15 hours.
Well, 12th, the waybill expires, my lord, at 3 o'clock, my lord.
No, 12th of which month?
No, 12th of August, my lord. My lord, it was intercepted on 4th of August, my lord. 4th April, 2024.
4th April, it was intercepted.
My lord.
A waybill was expired on?
My lord, midnight, my lord, 3rd. At 12 o'clock, my lord. And the waybill is to be renewed by 8 hours, my lord.
Yes.
In the morning, 8 o'clock, my lord, and the same date, my lord, at 3 o'clock it was.
On 4th itself, it was ready.
My lord, it's covered by your lordship judgment of my lord Ashok Sureka, my lord. And this is the only issue, my lord.
Let us see the order passed by the appellate authority.
My lord, appellate authority order is, my lord, if lordship comes down to page number 111, my lord.
111.
My lord, and the respective part is 116, my lord. Starts from 111, my lord. In fact, my lord, 113, my lord. Today I proceed to pass the appellate order in a separate sheet. In 130, my lord, the fact of the case has been.
So it was intercepted and detained at 3:10 p.m. So the vehicle was moving without a valid e-waybill from the midnight of 3rd of April.
My lord.
So you could have extended it by 8 a.m.
By 8 a.m.
What time you extended it?
But it was not extended, my lord. My lord, it was very near to the destination of delivery, my lord.
So
Well, actually, what happened, my lord, on 1st of April, my lord, 2024, there was a cyclone in the northern West Bengal, my lord. Or there was at that pertinent point of time, subsequently, my lord, there was the chief minister was over there for the cyclone relief, my lord, all this was going on. And there was a diversion of the traffic, my lord. And that was the reason for the delay.
But have you stated so in your grounds of appeal?
My lord. In fact, if lordship comes down to my lord,
but then the vehicle reached the destination without a valid e-waybill.
My lord.
On 4th.
On 4th.
You show your grounds before the appellate authority?
My lord, page number
page 82.
82 one.
You show this particular ground.
Batch. My lord, paragraph number 3, starting. Paragraph number 3 is that on the way to his destination on 4/4/2024 at 3:10 p.m. at a place near Kanki, named Kanki at NH31, 90 kilometers away from the destination, the said conveyance was intercepted by the Assistant Commissioner of Sale Tax, Bureau of Investigation, North Bengal, Raiganj Zone, Uttar Dinajpur, my lord. At the time of interception, the proper officer took a statement that the driver in charge of the conveyance that the driver has produced the document e-waybill, e-invoice. My lord, the e-invoice was over there, my lord. Well, but the system is that what is the necessity of a waybill, my lord, to record the transportation of the interstate goods, my lord, in the portal, my lord. Now, my lord, there is
that is one of the ingredients to be proved movement of goods for the you to avail credit.
My lord, my lord. Now, my lord, equally, my lord, all these my lord, detail go into the invoice portal, my lord.
The officer does not dispute any of your transport documents.
No.
The weight of the consignment also not in dispute.
No.
Identity of the consignment not in dispute.
Well, my lord, page number 51, lordship comes, my lord. The weight, my lord. Lordship, come down to 51, my lord.
1 second.
My lord.
What was the consignment?
My lord, veneer, my lord.
Huh?
Veneer. My lord, plywood veneer, my lord.
Oh, plywood vinyl plywood.
My lord. Well, page number 51, my lord, the report, my lord.
The e-waybill was generated on 28th of March.
My lord, e-waybill was generated.
Yes, 28th of March.
My lord.
And the vehicle was traveling 1095 kilometers from Manipur to Raiganj. And 90 kilometers before the destination, it was intercepted.
And the in page number 51, my lord, there was no difference in the quantity or the subject, my lord, veneer, which was.
But then, sir, at least in other cases, they took an attempt to generate a e-waybill belatedly. But here, what has happened? You did not take any step to generate a bill.
Even there are certain judgments of the single bench also, whereof, my lord, there was no waybill subsequently, my lord. My lord, after interception, my lord.
How much is the penalty imposed?
200%, my lord.
And the section says.
Of the value of the tax. 129 1A, my lord.
129?
1A.
Is it extracted anywhere?
My lord. No, my lord. The 129, one has been extracted, not 1A, my lord.
Can you just give that WBGST Act?
In fact, my lord, the single bench nowadays, my lord, it is passing any order whereof, my lord, if the delay is less than 12 hours, 24 hours, my lord, penalty is cost.
But something has to be imposed. At least token penalty should be imposed. Otherwise, these fellows will not 129 1A. On payment of penalty equal to 200% of the tax payable on so and so. On payment of an amount equal to 2% of the value or 25,000, whichever is less, where the owner of the goods comes forward for payment of such penalty. So minimum is 25% or 2% of the value of goods. Here they put 2%. No.
200%. 200%. But 2% is in cases where
exempted goods.
Exempted.
You give those judgments.
Well, but this is document, my lord, on that particular 2 days, my lord, 3 days before, my lord, the cyclone, my lord.
And have you raised the cyclone plea in your grounds?
Yes, yes, my lord.
Where?
My lord, page number that we were going through, page number. Paragraph number 3, my lord, page number 83, my lord, 84, my lord.
And the authority does not dispute this.
Well, even does not takes into consideration, my lord, this submission. Well, at the time of interception, the driver explained the fact to the proper officer as regards to the various highway blockage due to political rally and CM visit post-cyclone in Jalpaiguri district. The vehicle got delayed and the driver of the vehicle was unaware that the e-waybill needs to be extended by validity, but the same fell on it.
You give the judgments.
Well, this is your lordship's judgment, my lord. And
There is one judgment we said that mens rea also has to be examined.
my lord.
Are you carrying that? The intention to evade payment of duty.
In fact, my lord, in Ashok Surika also, my lord, lordship has discussed about mens rea, my lord.
Where in this judgment?
My lord.
Case has to be approached by considering the bona fides of the transaction as to whether the case warrants detention of goods and collection of tax. Admittedly, first evil so and so. The absence of second evil could not have intercepted it. Therefore, the explanation offered so and so is an acceptable explanation. And case cannot be made out that there was a deliberate and willful attempt to evade payment of tax so as to justify invocation of the power and response. Please come. Sir, tomorrow you find out. by the writ petitioner is directed against the order passed by the learned single bench in WPA 3188 of 2025, by which the learned single bench held that there is no scope for passing any interim order and directed affidavit in opposition to be filed. Since the issue involved in this appeal, as well as in the writ petition, lies in a narrow campus, with the consent of the learned advocates appearing on either side, this appeal, along with the writ petition, namely WPA 3188 of 2025, is taken up for hearing and disposed of by this common order and judgment. The appellant filed the writ petition challenging order passed by the appellate authority dated 2nd November 2024 under section 107 of the WBGST/CGST Act 2017. By the said order, the appellate authority confirmed the penalty imposed on the appellant, namely rupees 73,161, correct? 0.00 under section 129 of the Act, on the ground that the e-way bill, on the ground that the goods were being transported without a valid e-way bill. Section 129 of the Act deals with detention, seizure and release of goods and conveyances in transit. Subsection 1 of section 129 commences with a non-obstantly clause stating that notwithstanding anything contained in the Act, where any person transports any goods or stores any goods while they are in transit in contravention of the provisions of the Act or the rules made thereunder, all such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released on payment of penalty equal to 200% of the tax payable on such goods, and in case of exempted goods, on payment of an amount equal to 2% of the value of the goods or 25,000 rupees, whichever is less, where the owner of the goods comes forward for payment of such penalty. The other subclauses/subsections in section 129 may not be of relevance to the case on hand. So, which is the provision which permits, extension by 8 hours?
Well, Rule 138. If I'm not wrong, 138(8), I think.
Yes. Rule 138 of the West Bengal Goods and Service Tax Rules 2017 deals with information to be furnished falls in chapter 16, Roman 16 of the rules, which deals with E-way rules, E-way rules, E and W capitals. Section 138 deals with information to be furnished prior to commencement of movement of goods and generation of E-way bill. It is not in dispute that the appellant writ petitioner had generated the E-way bill on 28/3/2024 and the goods were transported from the state of Manipur to Raiganj in the state of West Bengal, covering a distance of 1095 kilometers. Sub-rule 10 of Rule 138 deals with the period, the validity period of the E-way bill, which is being generated by the transporter / owner of the goods. The second proviso under sub-rule 10 of Rule 138 states that provided further that where, under circumstances of an exceptional nature, including transshipment, the goods cannot be transported within the period of E-way bill, the transporter may extend the validity period after updating the details in part B of form GSTEWB-01, if required. The fourth proviso states that provided also that the validity of an E-way bill may be extended within 8 hours from the time of its expiry. Thus, the scheme of the rules does provide for extension beyond the period of expiry of an E-way bill. As noted above, the E-way bill in the instant case was generated on 28/3/2024 and the goods commenced its movement from the state of Manipur to travel to cover a distance of 1095 kilometers. The E-way bill expired in the midnight of 3rd of April 2025, and by applying the third proviso under sub-rule 10 of Rule 138, the appellant could have extended the validity of the E-way bill up to 8 a.m. on 4/4/2025. However, it was not done so, and the vehicle continued to move, and about 90 kilometers from the destination where the goods had to be delivered, the vehicle was intercepted on 4/4/2025 at 3:10 p.m. At the time when the vehicle was intercepted and detained, admittedly, the E-way bill had expired. However, there is no allegation against the appellant with regard to the quantity of the goods, the nature of the goods, the invoice details, and other documents. And the only allegation against the only charge against the appellant is that the E-way bill was not extended beyond the midnight of 3rd of April 2025. Undoubtedly, transporting goods without a valid E-way bill may result in an action to be initiated under section 129 within bracket 1 of the Act. However, it is not in all cases where the E-way bill had expired, the authority can come to the conclusion that the penalty at the rate of 200% of the tax payable should be imposed. In the instant case, the appellant pleaded certain facts before the authorities, stating that the highway was blocked due to political rally and the visit of the Honorable Chief Minister to the post the cyclone in Jalpaiguri district, where relief material were distributed to the general public of the area. And therefore, the vehicle had to be diverted, and this delayed the time. This delayed the and this caused delay. And it is stated that the driver was an illiterate, was not fully conversant that the e-way bill has to be extended. Extended, more particularly when the vehicle had to cover only a distance of about 90 kilometers to reach the destination. The copy of the weather report generated from the website of the meteorological department has also been produced to justify the stand taken by the appellant that due to inclement weather and other conditions, the vehicle could not move at the desired pace. More importantly, what is required to be considered is whether there was any intent to evade payment of tax. There is no such allegation against the appellant. That apart, the reasons given by the appellant regarding which led to the blockage of the highway has not been disputed or dealt with by the original authority or by the appellate authority. In such circumstances, it has to be seen whether the penalty at the rate of 200% has to be imposed. In the absence of any intent to evade payment of tax, in all cases where there is a in all cases where the e-way bill had expired, that too within less than 24 hours, the authority should take an informed decision and consider other aspects as well. In the instant case, the authorities have not disputed any of the other documents, nor the nature of the goods, nor its weight, or any other documents concerning the vehicle in which the goods were being transported. Therefore, we are of the view that this is not a fit case where 200% penalty should have been imposed on the appellant. In more or less similar circumstances, in the case of Assistant Commissioner, State Tax, Durgapur Range, Government of West Bengal versus Ashok Kumar Sureka, proprietor of Shubham Steels, MAT number 470 of 2022, dated 12/5/2022, the court dismissed the appeal filed by the state and affirmed the order passed by the learned single bench, which had set aside the penalty. In any event, when the statute mandates that there should be a valid e-way bill, the appellant cannot shirk such responsibility. However, we take note of the conduct of the attendant circumstances which appear to have prevented the appellant from getting the e-way bill validated within the 8 hours. However, for the default committed by the appellant, which resulted in the movement of the goods without a valid e-way bill on 4/4/2025 up to 3:10 p.m. would definitely warrant a notional penalty and not penalty at the rate of 200%. 25,000. In the result, the appeal is allowed, or no, the appeal as well as the writ petition is allowed, and the orders passed by the appellate authority and original authority levying penalty on the appellant at 200% is set aside, and the penalty is reduced to rupees 25,000. The appellant having already remitted the penalty amount, you have remitted the entire penalty amount, the authorities are directed to deduct 25,000 from the amount already remitted and refund the balance to the appellant within a period of 3 weeks from the date of receipt of the server copy of this.
Well, if the 25,000 can be broken up into 12.5 thousand, my lord, under the CGST as well as the IGST, by SGST, my lord, to refund it, it will be comfortable, my lord, convenient, my lord.
In order to facilitate the refund, the 25,000 rupees 25,000 which shall be recovered as penalty shall be equally divided towards the penalty under WBGST Act and CGST Act. So, and the remaining amount be accordingly refunded under the respective enactments.
Okay.
Good. You tell Mr. Tanay Chakravarti this has happened.
But he was in court number 5, my lord, in the morning. I told him that.
No.
I'll be appearing.
This is what is it, Mr.
I'll tell, my lord. I'll convey it.
Siddiqui is not there.
Yes.
So he is finding it difficult.
Well, I'll convey it.
Only 2 of them are dealing.
Yes.
Next.
Serial number 7.
Contempt action.
Time for the petitioner, Lordship.
You have served the respondent.
Lordship.
And who will appear for the respondent? Where is your affidavit of service?
Lordship, after communication of the order, they issued one notice, Lordship, for hearing.
Hearing notice,
Lordship. But
hearing contempt.
Lordship.
Then you appear on 7th. We will keep the adjournment.
But 21 days or limitation period from communication of the hearing should be made. But that was not complied, Lordship.
All right. First hearing you attend.
Lordship.
You want the contempt to be kept pending?
Lordship, let them remain pending, Lordship.
Okay. We have heard the learned advocate appearing for the applicant. Notice has been served on the respondent, but none appears for the respondent. It appears that after notice of contempt has been served, notice of the contempt application has been served, the alleged contemptor, namely the Block Land and Land Reforms Officer, Domju, Howrah, has issued a notice dated 28/7/2025, fixing the hearing on 7/8/2025 at 12 noon. Under which provision it says 12 days?
BLR.
No, 12, you said 12 days time should be given.
21 days. 21 days time was given, Lordship, in the order.
In our order, all right. We direct the applicant to attend the hearing and make submissions, and the authority shall take note of the submissions and the documents that may be placed by the applicant, and after following the directions issued in the order dated 10/4/2025, pass orders on merits and accordance with law, assigning reasons. Let a copy of that order be placed before this court on the next hearing day.
That will be your Lordship.
List the matter on 21st August.
Lordship, get pulled together.
Serial number 8 and 9.
Lordship, item number 8 and 9, I am for the respondents, your Lordship.
I'm for the appellant. I'm praying for not today.
What is this matter, sir? Member Secretary.
Lordship,
I'm led by Mr. Shivshankar Banerjee.
Lordship, may I please, your Lordship? Lordship, this is about victim compensation application granted to human trafficking victims, your Lordship.
And what happened in this case, Your Lordship, 75% amount of the disbursed amount that was granted to the victims was directed to be made fixed in a FD account for 10 years by the SLSA. Now, Lordship may find that order.
No, I think it is better we don't hear the matter, because when was this claim made?
Lordship, it was in 2020. Lordship may find the order on page number 70, Your Lordship.
Page number?
70, 70.
70.
Your Lordship,
There are
may I
three
place Your
page
Lordship?
numbers.
Page number 70, Your Lordship. 509.
Wait. There are 3 page numbers in every sheet. Which 70 we don't know.
On the paper book, Your Lordship.
There is no paper book. Oh, paper book is here.
Lordship, on the third paragraph, Your Lordship. The victim girl is directed to deposit 75% of the awarded compensation amount with the transferee bank in monthly income scheme in the name of the victim for a period of 10 years with auto renewal option, and submit compliance of the same within 40 days of the date of receipt of victim compensation. In default, necessary action will follow.
Now, the writ petition was filed, is it?
Writ petition was filed, Your Lordship, and it was, and my lord may find the order of the single judge is on page number 86 of the paper book, Your Lordship.
86.
86, Your Lordship. My Lordship may kindly come to page number 97, paragraph 19, where Honorable Single Judge has considered the entire case. Paragraph number 19 on page number 97, Your Lordship. May I place it?
Wait. No, because I was also the executive chairman of SLSA. I
Yes, my
remember
lord.
this file coming to me on the administrative side.
Yes, my lord, I know that.
And I think it is during my period. Where is the appeal memorandum?
Appeal memorandum is on Lordship on page number 108. It was in 2020, Your Lordship. Lordship is right. Lordship might have been the chairman at that time.
2020.
Yes, Your Lordship. And order for stay is on 116, Your Lordship. We are suffering a stay. Is 116, dated 28 September 2020.
Deposit.
My lords.
No, I think I don't hear. I think it's better I don't hear this. Initially, in fact, my assignment order is there.
My lord has assigned the matter.
Yes. Because I didn't go through the entire facts. In fact,
My lord, the only issue is that, my lord, we are suffering a stay.
No,
and
I
this is
will
to human-
assign it on Monday. It will be assigned.
My lord,
On
my lord.
account
It cannot be on Wednesday because Mr.
No, no.
Banerjee will be not.
This bench
No, my
won't
lord, this is pending for pretty long time, my lord. It's
Yeah,
been
yes.
2020. And many victims are also affected, my lord knows.
Actually, though victim compensation was sanctioned, nothing was paid. You remember? Then
Yes, your lordship. Yes, your
petition
lordship.
was filed, judicial side. Then Chief Justice Prakash also assigned it to me when I was AD1. Then we put so much of pressure. Thereafter, they released in 3 tranches.
Yes, your lordship.
That is
Lordship,
how
I
the
remember that I have also appeared before my lord on those occasions at times.
that is as one of us put my name had
Lordship, I'm read by Mr. Kaushik Gupta, your lordship. Yes.
had on the administrative side, while functioning as the executive chairman of the, while nominated as the executive chairman of the West Bengal State Legal Service Authority, has dealt with the subject matter. The matter stands released from this court. Let the papers be placed before the Chief Justice for appropriate orders.
Deeply obliged, your lordship. Lordship, any date for assignment your lordship is pleasing?
Monday, the file will come to me.
Monday.
Monday,
Gratefully, your lordship.
assign it, and I'll also request the bench to give some priority.
Gratefully, your lordship. Deeply obliged.
But whether Justice Basak has heard the matter at any stage?
Justice Boshak has heard the matter, your lordship, and thereafter Justice Shane also has released the matter because presently Justice Shane is also the chairman.
No. Justice Devanshu Basak.
Yes, your lordship. Justice Boshak has heard the matter. One of the writ petitions were before while Justice Boshak was hearing the matter in the single bench.
Oh, so he had
to release your.
He can't hear the matter. The Somanson has already released it. We have released it. Monday it will be done.
Gratefully, your lordship. Gratefully, your lordship.